Thank you all. Please be seated. Good morning. This is a time set for oral argument in Thakrar versus Paula, our case number CV190043. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time. If you wish to do so, you need to keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask that those in attendance make sure their cell phones are off to avoid embarrassment and interruption. We've read the briefs, we've conferenced the case. We'd encourage you to keep that in mind as you proceed with your oral argument. Proceedings are being recorded and will then be posted onto YouTube, so please, as you begin your argument, start by telling us your name and the party you represent. With that, Mr. Barnes, you may proceed.
Good morning. May it please the court. I'm John Barnes, here for the appellant, Surrender Paula. With me at counsel's table is Lori Vopel. I'm going to reserve 5 minutes of my time for rebuttal, and I'd like to start by addressing the questions outlined in the court's order. The first question asks whether the determination that Mr. Paula breached the partnership agreement is entitled to deference. Well, as a threshold matter, contract interpretation is a question of law. This court reviews de novo, and that issue would not be entitled to deference. But with respect to the factual finding of breach, whether that's entitled to deference depends on whether there's substantial evidence in the record supporting the finding.
In that vein, I'm sorry to interrupt.
Please, Judge.
I have just a big picture question.
Sure.
And that is, you didn't request findings of facts in this case, did you?
We did not.
And when you don't do that, isn't it basically if there's any evidence in the record that would support a factual finding, that would support the trial judge's decision?
Well, the cases on that issue, and I cited a few in my supplemental citation of legal authority filed last week, say that even when the parties don't request findings of fact or conclusions of law, the analysis still turns on whether there's substantial, as some courts have articulated in terms of reasonable evidence in the record. There has to be something in the record to support the trial court's finding.
That's what I said, any evidence.
Well, I mean, I think it has to be of substantial evidence. It has to be more than just a mere scintilla. It has to be something concrete that will support the trial court's finding. And that actually is a perfect segue into the court's second question, which is which specific contract provisions and what facts in the record support the finding of breach. Now, the answering brief identified 5 alleged breaches without specifying any particular contract provision that was supposedly breached. Those 5 supposed breaches are that Mr. Paula supposedly failed to disclose his lack of restaurant experience, stopped going to the restaurant, failed to exercise the option to join the LLC, failed to disclose his bankruptcy, and failed to get the restaurant opened in a timely manner. Those are the 5 breaches outlined in the answering brief, and I think that's page 20. And none of them hold up under scrutiny in view of the language of the contract agreement.
So you can just stop going to a restaurant that your client admitted he was obligated to go to, and that wouldn't be a material breach.
In this case, I think we have to answer that question based on the contract language. And it's Trial Exhibit 76. Under the withdraw or death section, very first sentence says, "The partners hereby reserve the right to withdraw from the partnership at any time." That was an absolute right all the partners enjoyed. At any time they could withdraw. No questions asked.
So if he's just stopped going to the restaurant, does that mean he withdrew from the partnership?
Well, that's what the trial court found. And as I explained in the briefing, there was no cross appeal on the issue of Mr. Thakrar's breach, and so I think that factual finding stands insofar as this court's analysis of Mr. Paula's breach. And so just to go through the alleged breaches in the answering and brief, and I want to do that specifically because if I have to in my rebuttal time, I want to be able to argue that if counsel intends to argue some other conduct supports the finding of breach, that the issue was waived because it doesn't appear in the briefing. For example, the argument that Mr. Paula failed to disclose his restaurant experience. Well, nothing within the four corners of the agreement says that Mr. Paula even had to have restaurant experience, much less disclose what that was at the outset of the enterprise. And in any event, his testimony was undisputed, that he owned or operated 2 restaurants prior to the one at issue in this case. Number 2, we already addressed the fact that he stopped going to the restaurant. That was a withdrawal under the plain language of the agreement. Number 3, the argument that he failed to exercise his option to join the LLC. I still don't understand that argument, because typically when we're talking about breach, we're talking about duties. You can, duties arising in tort, duties arising under a contract. You can breach a duty. How can you breach an option? Because the definition of an option means you have a choice whether or not to do something. So I don't think the contract embraces any reasonable interpretation that amounted to a breach. Number 4, that Mr. Paula supposedly failed to disclose his bankruptcy. Again, nothing in the contract required him to disclose a bankruptcy or anything to do with his financial standing. In fact, what the contract shows is that Mr. Paula had no obligation to put up any capital contributions during the business startup phase, because frankly he didn't have any money at that time. And it was Mr. Thakrar who assumed full responsibility for all things financial: bill payments, accounting, bookkeeping, etc. So I don't think that the bankruptcy supports a finding of breach. Finally, the 5th alleged breach is that Mr. Paula failed to get the restaurant opened in a timely manner. Again, nothing in the contract includes a timeliness requirement. It certainly doesn't include one that places that requirement squarely on the shoulders of Mr. Paula. And in fact, when considering that issue within the circumstances of the case as a whole, the opening of the restaurant perfectly coincided with the end of the free rent period that came with signing the lease. So if there's any inference to be drawn there, it's that the restaurant did open timely.
Also, you've mentioned the terms of the partnership agreement, or agreements, I guess.
Right.
Does a good faith, fair dealing obligation that's implied in every contract have any sort of traction to the analysis here?
Well, the cases say that a breach of the duty of good faith and fair dealing is a tort. And
there's 2 lines of that obligation. There's a tortious aspect of good faith, fair dealing, sometimes called bad faith.
Right.
I'm talking about a different line of that, the line that's implied in every contract.
Well,
that would, if applicable, provide the basis for a contract.
Well, 2 points to that, Judge. Number 1, I don't think that second line of reasoning that you're referring to was raised in the answering brief. So I think that issue would be waived. And second of all, the contract does include an implied duty, but there's nothing in the circumstances surrounding the execution of the contract in this case. Nothing in the record that would support a finding that that was a breach in this case. And I assume you're referring to the bankruptcy issue. No.
I'm actually, it's more broadly than that. Was that issue raised in the trial court, the good faith, fair dealing obligation as a contractual breach?
I don't think so, Judge. But I can't point to any specific page in the transcript that would help you answer that question. And so just to wrap up the answer to the court's second question, none of the 5 alleged breaches in the answering brief support the trial court's verdict on the breach of contract claim against Mr. Paula. Turning to the court's third question regarding extrinsic evidence, the Astar case cited in my briefing articulates the parole evidence rule. And in a nutshell, extrinsic evidence is not allowed to vary or contradict the plain language or the written terms of an agreement, but it may be allowed where those written terms are reasonably susceptible to the interpretation proffered by the proponent of the extrinsic evidence. And in this case, as we just discussed, Mr. Thakrar failed to identify any evidence, much less parole evidence, that Mr. Paula breached. The parole evidence that he did identify, namely testimony that he was somehow entitled to withdraw his capital contributions before anybody else got paid, which I think is a damages issue, but that directly contradicts the written terms of the agreement. And again, it's Trial Exhibit 76 under the contributions section. I'm quoting, "The capital contributions are final unless all partners give written consent of withdrawal." And there's no written consent here. And the testimony that some oral agreement supports withdrawing capital must be rejected as improper parole evidence. And finally, the court's fourth question asks, what are the consequences if the breach finding is overturned but the no damages finding is upheld? Before I get into that, I have to make a record on the damages issue, because I think undisputed evidence supports a finding that Mr. Paula had damages. Number one, it's undisputed that he owned half of this business. He was a 50% owner, and that's directly out of the partnership agreement.
I thought you just said to one of my questions earlier that he withdraw, the failure to appear would be a withdrawal.
He did withdraw, and turning back to the contract, that triggered a process for winding up the business. I read to you the first sentence saying that any partner has the right to withdraw at any time. And after that, there's some language in the same paragraph about giving the remaining partners an option to purchase the departing partner's shares. And then in the next paragraph down, it says if there's no agreement to purchase those shares, the partnership's dissolved. And then, so that triggers the dissolution paragraph, which is the next one down. And under the dissolution paragraph, the assets shall be liquidated, and all remaining funds after debts have been paid will be distributed based on the percentage of ownership interest outlined in this agreement. And Mr. Paula had a 50% ownership interest. So at the time
of a business that hadn't even started yet.
Well, it had started to begin building the business. Essentially, all the money and time and effort that went into building this business, it all had value. Just because Mr. Thakar's money had a dollar sign assigned to it, doesn't mean that all of Mr. Paula's time and effort was worthless.
You had a marketable business at the time it was alleged that he stopped showing up at the restaurant.
What's the question?
You had a marketable business at the time that he's alleged that he stopped showing up at the restaurant.
Well, it wasn't open, but
Well, that's my point.
we had a business, and it was being built. There was remodeling, chefs were hired, menu was prepared, signage was prepared. All of that time and effort.
Again, was it a marketable business at that time? You're saying it was
in terms
going to
of
be liquidated. Well, okay, what were you going to sell? That concept?
Well, I suppose we'll never know, because that didn't happen. But under the express language of the contract, that's what should have happened. They should have liquidated the assets at the time and divvied up whatever that was.
Mr. Paula was also responsible for, was it 50% of the costs?
Mr. Paula's obligation to pay operating costs, well, he left the partnership before the business incurred any operating costs. So that obligation was never...
I'm sorry, you had just said that there were chefs hired, and so were there were no costs that could be attributed to operating costs at the time that this concept could... I'm having trouble tracking how...
Right, I
there
see
could
your
have been
question.
something that was subject to liquidation without there having been any...
I think the partnership agreement embraces a reasonable interpretation that there were startup costs and there were operating costs.
Okay.
And Mr. Paula's
His only
obligation...
obligation was as to costs after the
Right.
opening of the business?
His responsibility to put up the capital for getting this business going was zero, because he didn't have any money at the time. His job was to put in basically his sweat labor into building this business, and he did that.
Until he stopped showing up at the restaurant.
Until there was a dispute among the partners. First, there were 3 partners initially. One got bought out by Mr. Thakrar, and then that left 2 50-50 owners. And when that relationship also deteriorated, Mr. Paula himself withdrew.
And what trial evidence was there that at that time, under your theory of the withdrawal, that the entity had a positive as opposed to a negative value?
Well, It had
Doesn't your theory turn on that?
it had a prime Scottsdale location, and it had all.
And I understand all that, but it's really more a balance sheet question. What trial evidence at that time of the withdrawal, under your view, is there that this thing had a positive as opposed to a negative value?
Well, I don't think that there is any accounting evidence, but the parties agreed that at the time it was going to be worth $200,000. That was what they agreed.
Did they agree that, or was there trial evidence indicating that at least one of the partners valued?
Well, that was the testimony from Mr. Thakrar.
Right.
And I don't think he can stand up here and say that now he didn't.
I was struggling with and in your brief as well, with the phrase agreement, because that might be an admission, but I don't know that was an agreement. But
probably an admission would be a better way to put it, Judge. I hope that answers
it does.
Your question. And so, Mr. Paula, he was 50% owner. We have an admission of what the business was worth at the time we withdrew, and we have a free market determination of what the business was worth when it finally sold. So all of that evidence is undisputed. Also undisputed is the fact that Mr. Thakrar's capital contributions did not create a debt or a loan that required repayment, referring back to the language from Trial Exhibit 76 regarding contributions. And so that constellation of facts, I think, establishes a lack of a dispute that Mr. Paul is entitled to damages, because frankly it's just not fair that the trial court determined both parties breached and yet Mr. Thakrar gets to keep all the money. There's just no equity in that.
Fair, but we're here on a legal claim, not an equity claim, correct?
Right, Judge, yes, correct. But to answer the court's question, I haven't answered question number 4 yet, and I'm running out of time. What are the consequences? Well, the case needs to be remanded with instructions to enter judgment for Mr. Paula on Mr. Thakrar's breach of contract claim, and the attorney's fees judgment needs to be vacated so that the trial court can determine in the first instance which fees, if any, to award, because the trial court would have discretion not to award fees on the failed breach of contract claim.
I want to get back just for a moment to the question of trial evidence on Mr. Paula's breach. Setting aside what's raised in the answering brief, the language that sets forth the obligations, if I have it correct, is that Mr. Paula was responsible for the day-to-day management and operation of the restaurant, including food inventory, staff, hygiene, cleanliness, and customer relations.
That's what it says.
I understand that there was evidence in the trial court on at least some of these points, that there were inspections either missed or failed, that there were problems with the staff. Given that you didn't request any factual findings, and we are thus presented with a trial court verdict that Mr. Paula breached, we have that verdict, we have this language of obligation, and there is trial court record evidence of failure to meet some of these obligations. Can we affirm on that basis, finding that that's substantial evidence of material breach?
2 points on that, Judge. I don't think that that's true, that Mr. Paula was involved in the failure, the inspection failures. Are you referring to the health department closure? That happened after Mr. Paula had withdrawn from the partnership, so I don't think that can be attributed to him. And the second point I wanted to make was there's no standard of review in this contract, and the contract certainly doesn't make Mr. Thakrar the final arbiter of what is satisfactory performance of this duty. Effectively, the contract gives Mr. Paula carte blanche how to manage the operation. And if Mr. Thakrar was unhappy with how Mr. Paula was doing that, his remedy is in the contract, and that was withdraw and winding up the business. It's not a breach of contract claim. And I think it's contracts 101. You can't hire someone to paint a painting that you like, and then when you don't like the painting, say it's a breach of contract. It's an illusory contract. And I think to the extent that the court, I just don't think the court can affirm a breach finding based on Mr. Thakrar's stated dissatisfaction with how Mr. Paula manage the business. And with that, I'll save my remaining 57 seconds.
Very well.
Thank you.
Mr. McGill.
May it please the court. The first point I would like to address, Your Honors, is the deference. This case is not unlike virtually every case I would imagine that comes to the Court of Appeals in a jury trial setting or a bench trial setting. And here, I think what's important here is that this was a bench trial. So that's a compelling concept here in this appeal, which is that the trial court was serving as the finder of fact and the trial judge on questions of law at this trial. And I would think that that would be very important to this court, with all respect to the Court of Appeals, in considering deference to the trial court in this particular case, given the record that's here. The second
Mr.
point.
McGill, one of the things that is different about this case than many of the others is that there are no findings of fact. We do have the verdict, but while the trial court was the finder of fact, we don't have any explicit findings of fact on which to evaluate that verdict or to which to defer. Isn't that
Well,
a big difference?
That's true. And that's why, in that context, we go to the second analysis, which is under the Ziggy's Opportunities case versus I-10 Industrial Park Developers. It's 152 Arizona 104, and it's cited on page 6 of the answering brief. Under that case, the Court of Appeals, and under the Neal versus Neal case, 116 Arizona 590, and then there's a prior case dating back to 1948, Porter versus Porter, 67 Arizona 273. Those cases hold for the proposition that, and as I understand it, the Ziggy's Opportunities case was a bench trial case. The principle in that trilogy of cases is the following, quote, "This court on appeal must presume that the trial court found every fact necessary to support the judgment. The judgment must be sustained if the evidence on any reasonable construction justifies it." That's the standard here today. And so then we go to the next analysis. Given this relatively strong presumption that operates, that this court should presume that the trial court, sitting as the trial judge and the finder of fact, found every fact necessary to issue its judgment. That's the presumption. And counsel has not overcome that presumption. As I understand it, the only way that defense counsel can overcome that presumption is if the record is devoid of any facts that would reasonably justify the trial court's judgment. And when you look at the record that was presented, and the appellate brief did go through all 4 days of the trial testimony. I went through in the appellate brief and tried to lay out the material adverse facts against Pala on day 1, day 2, day 3, and day 4 of the trial. I went through and canvassed those 3 days and went through and cited in the answering brief the specific transcript portions of the testimony on each of those 4 days and provided the court with evidence that contradicts, with all due respect, what defense counsel just told this panel. And that is, there were multiple examples at trial based on the trial exhibits and the testimony of material breaches by Mr. Pala. And I can go through those examples. And again, I would ask this court, with all respect to the Court of Appeals, to keep in mind that we have a bench trial where the court was serving as the trier of fact, and the trial court, and the presumption that operates in the absence of findings of fact and conclusions of law.
Mr. McGill,
Yes, Your Honor.
Assuming that the trial court believed that Mr. Pollard did just stop coming,
Yes, sir.
is that a breach or withdrawal from the partnership agreement?
It's a material breach, Your Honor. This withdrawal notion is misplaced. First, I would direct the court to the Index of Record 240, which is the joint pretrial statement. And that, as this court is aware, the joint pretrial statement is the roadmap for the trial. That's the governing document that sets the scope and nature of the proceedings at trial. And as I understand it, under Arizona
Okay, you're
law.
not answering my question.
Yes, sir.
Was it a breach or was it a withdrawal?
I believe I said
Okay,
initially, Your Honor,
you
it was
said
a breach. It's a
and then
material
you were
breach.
going to tell me why
Yes.
it's a material breach.
In the joint pretrial statement, and that's what's interesting, because defense counsel focused on this withdrawal, because this is the first I've heard it on appeal. So that issue is clearly waived, because this notion that Pala withdrew from the partnership, that's not in the joint pretrial statement, which is Index of Record 240. I was the one who participated in this joint pretrial statement going into trial, and I participated in this roadmap that governs that. And so they waived that. That's not in the joint pretrial statement. It's not set out there. It's for the first time. It's in the appellate briefs and in the argument.
So they didn't assert in the pretrial statement that it was a withdrawal.
Right, a withdrawal from the entity, from the partnership, which is what I'm understanding, Your Honor.
They simply disputed that he didn't show up, or there was a double negative in there. They disputed that he failed to continue to maintain his duties prior to the opening of the restaurant. Isn't that correct?
Well, no, they did not. Well, Your Honor, and this is a nuanced factual point. It's a very good question. Pala admitted at trial that he stopped going to the restaurant. Thakrar testified that he stopped going on September 15th. The pertinent time period is the lease was signed in May. September 19th, this is all in 2012. Lease signed in May. There's a 6-month free rent period. The two contracts, the two partnership agreements, and my client testified both were operating, both were in effect because they didn't contradict each other. So they're both in effect. That's what my client testified to. Those were signed on September 19th. On around September 19th or September 15th, my client testified at about the time of the contracts is when Pala stopped going to the restaurant, which is a problem for Pala. And we believe the trial courts found that to be a problem too, because Pala did not dispute the fact. In fact, he testified, and I cited it in my answering brief, he testified that he stopped going around mid-September. That's when the two contracts were signed. Part of our lawsuit, part of our complaint, is the breach of the implied covenant of good faith and fair dealing on the contract, not tort. It was never brought as a tort, never argued as a tort, never presented as a tort. It was a breach of the implied covenant. In the implied covenant under the Wells Fargo versus Arizona laborers case, it's very clear. Neither party may do anything that disturbs or impairs the other party's reasonable expectations under the agreement. Otherwise, that could be construed as a violation of the duty of good faith and fair dealing. One of those breaches of the implied covenant is when Pala stopped coming to the restaurant at about the time the two contracts were signed. And we believe under the presumption that the trial court so found. To answer your question, Your Honor, Pala, there was no evidence from Pala that he continued to try to go to the site after September. For example, tried to go in October and was denied access. There was no testimony, and you won't find any in any of the trial transcripts, that he tried to enter or gain access to the site in October, for example, before it opened on November 1.
I thought there was an injunction against harassment,
There was, Your Honor.
and when was that put in?
December 14th. December
After the restaurant.
after it opened. Over a month or 5 weeks after it opened. And that's an important fact too, because after it had opened on November 1, my client testified that Pala then, he embarked on a campaign of retribution and was making threats, calling the landlord. And he's not even a party to the lease. Pala never signed the lease, didn't sign the guarantee. My client funded the operation, the startup. My client, Thakrar's on the guarantee. My client contributed $20,000 initial capital contribution, returned the $20,000 of BIP and Canabar, so he was in for 50% after he paid $40,000. And Judge Stevens asked him that. You returned the 20, and then we clarified, and he said yes. He returned the 20 to Canabar, so my client then came in at 50% ownership, and Pala purportedly at 50% ownership. But Pala never disputed that at trial. He never disputed that scenario. So
You kind of wandered off
the
a little bit there,
injunction,
but what,
the
yeah, let's get back
injunction
to the
was
injunction.
after it opened. And my client made all the capital contributions, paid all the money, was on the lease. Pala was contacting the landlord after it opened, 6 weeks after it opened, forcing my client in December of 12 to go in and get an injunction against harassment because Pala was making threats, contacting the landlord, and he had no connection or privity of contract with the landlord on the lease, contacting the chefs, trying to get the chefs to leave the restaurant, trying to sabotage the restaurant. All this evidence came in at trial. Judge Stevens heard all this evidence. And the injunctions were not contested by Pala. I cross-examined him on the injunction. He never contested the injunction. And that's in the trial transcript, that he did not contest it. He didn't file any papers to contest it, never went to court to contest it. He said, well, I was busy at the time and I didn't contest it. When I asked him why he didn't show up at the restaurant, he said, well, I only didn't show up when my wife was ill. And so that was a little bit vague. But he did it, he never testified that he tried to gain access in October, the month before it opened. The testimony was undisputed that he stopped in September, right about the time of the signings of the contracts. And I asserted at the trial court, that's prima facie evidence of a breach of the implied covenant. If you're signing contracts in the essence of the deal, the purpose of the transaction, in the contracts, the purpose of the transaction is to get the restaurant opened so that you can start generating revenue by November 1, which was the time the free rent expired. So the rent kicks in, which is $6,000 a month. It's a large nut for the business. And you got to have the revenue start. So this November 1 opening date was very important to my client who's funding this. And the record is undisputed that Pala, with all his purported experience, which we disputed at trial, and we believe the judge didn't buy all this experience. And the trial judge is the only one who could assess the credibility of the witnesses and weigh the evidence. And I would respectfully ask this court not to disturb the trial court's assessment of the credibility issues that were before the trial court during this trial. I mean, at the end of the day, the trial court had the burden, if you will, of assessing the credibility of the two testimonies and trying to determine who breached. And the trial court found that they both breached. Now, there are no findings of fact and conclusions of law as to which one breached what issue. But the presumption is, under the Ziggy's trilogy, is that there's evidence in the record that they both breached. And the trial court, it's not internally inconsistent for a trial judge to find at trial, based on the facts and the evidence, that there's a breach, but you haven't proven your damages to the requisite level, which is reasonable certainty under the Rancho Pescado case. I have that site. I'm sure the court is aware of it. It's Rancho Pescado, 140 Arizona 174, and the Felder versus Physiotherapy Associates, 215 Arizona 154. Those two cases are the seminal cases in Arizona, as this panel I'm sure is aware, that for Pala to come in and claim that he's damaged, the judge found he didn't show his damages with reasonable certainty. It's not internally inconsistent for the judge to find that there's a breach of contract, a material breach on liability, but you haven't proven you have the burden on damages and you haven't shown it with the requisite degree of reasonable certainty. That's not internally consistent. That's done all the time in contract cases. In fact, if that happens, in many cases, those cases are disposed of under Rule 56 summarily, because you haven't, at the close of discovery, there's insufficient evidence on damages. That doesn't happen very often, that it's disposed of on damages, but it does happen at trial, and it did here. I hope I answered your question, Your Honor.
Thank you.
And Your Honor, on the presumption, on the findings of fact. So on the breaches, Your Honors, I would make an appeal for my client. This case has been going on since 2012. We're in the 7th year, and it was up on appeal and went back, and we're back. We didn't appeal the judgment because we just felt like enough was enough. Judge Stevens is an excellent trial judge. Very open to both sides. Very fair. Very fair. Exceedingly fair. I had recommended my client. We're done. The judgment was issued, and it was issued on attorney's fees, $74,500 on the attorney's fees. I had asserted on the fees that, and I know the court didn't ask this question, but I thought I'd take a moment on the fees. I had asserted that the net judgment rule. There are some cases on that, and I cited it in my answering brief. Pala had brought 5 counterclaims. The only one the judge found liability on was breach of contract. Let me back up. Pala brought 5 or 6 counterclaims. We brought 3 claims: breach of contract, breaching implied covenant of good faith and fair dealing within the context of the contract, breach of fiduciary duty, and then an ouster, an injunction ouster that based on the bad acts, he should be ousted from the partnership. At trial, we made an election. Both sides had to elect. They elected to withdraw, for example, the fraud, because I guess defense counsel had made an assessment there was not clear and convincing evidence of fraud. I don't know what his calculus was, but he withdrew it. I withdrew the ouster claim. And so that's why when you go to the trial court's ruling on the trial, she goes through and may not have addressed all the claims in the pleadings because there was an election made and some were withdrawn. That was appropriate. But the 3 or 4 remaining counts on the counterclaim, 3 of the 4 went against Pala. 1 was on breach of contract, but he failed to show damages. In fact, the judge's minute entry, it's index of record 286. She said the court found both parties breached the contract at issue. Defendant did not establish he was owed any monetary damages at trial. That couldn't be clearer. That's not internally inconsistent, completely 100% accurate under the law. And that was within her prerogative. She determined at trial when at the end of the day, when she heard, because Pala's counsel at trial, which is not the appellate counsel, was bringing in certain data of the company. There was no evidence at trial of any lost profits. Profit is revenues crudely put. Profit is revenues minus expenses and maybe debt and some other ancillary overhead is your net profit. But there was no lost profit data introduced at trial. So the judge appropriately dismissed that. Lost profits have to be introduced with reasonable certainty. There has to be a reasonable or rational basis for the trial court to enter such an award. One of the questions this court had for the argument, if we were to reverse, overturn in favor of Pala, And that would be in the face of many examples of a breach by Pala. Stopping going in, the 44,000 in tenant improvements. He didn't hire licensed contractors. He didn't have receipts. That cost my client $44,000. If they had submitted licensed contractor receipts for the improvements that Pala was supervising, my client would have got $44,000 back. No food handler's license. Problems at the county health care. That was before the Pala. There were some issues there. Ordering excessive supplies. I went through a laundry list. But if the court were to overturn and reverse and find that Pala didn't breach this in some way, undisclosed bankruptcy, that was another breach. Then you go to the damages, and there was no proof of lost profits.
Mr. McGill,
yes, sir.
I see your time has expired. If you wish to wrap
Okay.
up in a sentence or two.
Last point, Your Honor.
In a sentence or two.
Thank you. In the damages, the $3,000 per month, that was not to be paid until after the restaurant opened. And so that never came in. If there's a material breach, and the law is well settled on this, if Pala materially breaches, that excuses Thakrar of his obligation to go forward, because he doesn't have to do a futile act and watch all of his investment implode while a party is in material breach. He has the right to act on that and try to mitigate.
Thank you, Mr.
Thank you.
McGill. Mr. Barnes, rebuttal. We'll give you 2 minutes in rebuttal.
Thank you, Judge. Just a couple of corrections, and I'd like to answer Judge McMurdy's question about whether, when Mr. Pala withdrew, what I heard counsel say is that was a breach, but withdrawal is what the trial court found, and I think that's the
I
finding.
didn't think the trial court made a specific finding.
Well, actually, it did. Not in the minute entry, but this was in the transcript.
Let me ask you this: Did you put that in the pretrial statement that your client withdrew by failing to show up? That was an act that was a withdrawal.
Frankly, Judge, I hate to use this answer, but I don't know the answer to that.
Fair.
I would have to look back at the pretrial.
Okay, so
but
the record speaks for itself.
it will have to. And what I can say on the record is that in the hearing transcript, the trial judge found that inherent in the court's ruling was that there was a partnership. That's the November 27, 2018 hearing transcript on page 5. Later on page 11, she says, I don't know, they're discussing the attorney's fees issue. I don't know the time frame for those, but clearly it was the court's intention to find that there was no breach of contract because there was no partnership after Mr. Pala left the restaurant. That terminated the partnership there, so there was no partnership. He withdrew from the partnership. So that finding is in the record, Judge. Our position is that the withdrawal was not voluntary, but was forced. And there is record evidence supporting that. Contrary to what I heard counsel say, Mr. Pala testified. He stopped going to the restaurant, and this is day 4 at page 10. He stopped going due to conduct by Mr. Thakrar through counsel, sending threatening letters, later getting the order of protection, and then ultimately filing this lawsuit. But even if this court isn't willing to accept the argument that it was an ouster, his withdrawal was still acceptable under the plain language of the agreement. I also wanted to point out that the transcript shows Mr. Pala was still working from home when he thought there was still a partnership during the time his wife was ill. And I see that I'm out of time, so thank you.
You are. Thank you. Thank you both. Thank you all. We appreciate your briefs, appreciate your argument today. We'll take the matter under advisement. We'll issue a written ruling in due course. We'll stand in recess while the courtroom is set up for next oral argument. Thank you.